like to open the public, the ZBA meeting for March 19th. It's a continuation of last month's meeting. Applicants Terry Buck and Allison Group, Eastern River Avenue, Chatham, New York. All business is applicant Terry Buck and Allison Group, Fairview Avenue, application for appeal of orders, requirements, decisions, and determinations made by the code enforcement officer in relationship to applications and actions of New York State Energy and Gas and related to site plan approval and utility pole located at 18 Fairview Avenue. And that's what we're here to discuss. This is a few notes. This is a very loud room. Voices do not carry well and they don't translate well. We cannot have, and there's a lot of people here from the public, and there will be a public session of hearing things, but it will be orderly, it will be one at a time, and it will be limited. And we are here to discuss the issue at hand, the application at hand. We're not here to discuss, and maybe you want to add to what we're not here to discuss.
It's a very, very specific matter in front of the board tonight. It is an appeal of determinations made by the code enforcement officer in relation to this application. The only thing that they're enabled to hear is a question about the decisions of the code enforcement officer, and there are 6 of them that were alleged. Anything that the planning board did is off limits. This board has 0 review authority over the planning board. That is not before the board, and it is not lawful for it to be before the board. So if anybody has any thoughts on what the planning board could have done, should have done, or whatever, it is outside the limits of what is involved here tonight. So that shouldn't be brought up. It's irrelevant to what is in front of them. I know people have very strong feelings about things in a bigger picture kind of way. That is not the subject of the appeal. There are 6 questions that were distilled from all of this that are appeals of what are alleged to be determinations of the code enforcement officer. And I can read what they are. The applicants are appealing the code enforcement officer determination that the utility pole did not require a special use permit. Applicants are alleging that the utility pole is a non-conforming use which requires a special use permit. So that's just the question, did it require the special use permit or not? Second one is basically the same thing under a different code provision. But it was, again, if the utility pole was or wasn't required to get a special use permit. Third one is the applicant's appeal the determination that the expansion of the utility facility was permissible because it was within the 25% expansion that's allowed by the code. It's just a question of whether the utility facility expanded by more than 25% or less than 25%. The fourth one, the applicant's appeal the determination that the utility pole did not require an area variance for height. The fifth one is also related to a height variance for the pole. It doesn't have anything to do with what the pole is carrying, what the pole, the wires. It's just, did it need a variance for its height? And the last one was an allegation that public hearing notice wasn't provided. Those are the only things that are being appealed and that can be appealed. And so anybody that has any commentary has got to confine themselves to those specific points. And anything else is irrelevant to what is in front of the board tonight. So I just want to keep it on topic because it's a very narrow and it's actually quite a technical matter tonight. It's not an evaluation of the merits of the project. And so that shouldn't be what people are talking about. And if it is, I think the chair will probably say that's not pertinent to what we're doing here. And please be focused on these questions. So it's a very limited technical review of these determinations, and that's all. So there are a bunch of steps to go through in doing so. And some people who are here for the first time, I'm just going to go through a couple of threshold things that people should be aware of so they understand the process. The New York state law allows appeals of certain determinations. And to quote the New York State Village Law, the jurisdiction of the Board of Appeals.
Please turn off all cell phones. It's a smartphone, after all. I'm getting a haircut. I'm sorry.
Okay, so the jurisdiction of the Board of Appeals shall be appellate only and shall be limited to hearing and deciding appeals from and reviewing any order, requirement, decision, interpretation, or determination made by the administrative official charged with the enforcement, basically of the zoning law. Such appeal may be taken by any person aggrieved or by certain village officials. So that sets out the scope of what the village zoning board can look at and who can bring these appeals. A person aggrieved is a person must show they've been adversely affected by the activities, and I'm quoting actually from law or cases, or put in there that they have sustained special damage different in kind and degree from the community generally. So when something is being challenged under zoning, the person making that challenge or the appeal has to have a special interest in what's going on. For example, if somebody lived on Payne Avenue, their interest in this would clearly be just strictly that of a community member. They would have no standing as an aggrieved person. So someone needs to show that they are being particularly and specially adversely affected by the question. There's a case, there are lots of cases, but here's one appellate division case, which is an appeals court in New York. The quote, for standing to sue, petitioners must show that they have suffered an injury in fact, distinct from that of the general public. So there has to be showing that the people who are challenging are situated differently from the general public and are suffering a specific harm to them personally or to their property directly and not just as a member of the public more broadly. Another threshold factor is timeliness. After decisions are filed, an appeal shall be taken within, this is the statute, appeal shall be taken within 60 days after the filing of any order, requirement, decision, interpretation, or determination of the official. There is case law relating to that time period where it's strictly applied against an applicant. If an applicant goes to the municipality and applies for something and they're told they cannot do it, and they're directly told they cannot do it, they have 60 days, and that's a hard and fast number. When there's a third party, which is the case here, the 60 days is not necessarily strictly applied. It becomes a more complicated test about when they knew or perhaps when they should have known. And there are a variety of cases. Sometimes things happen where there's simply no reason why anyone would suspect that they had happened. If somebody walks in out of the blue to apply for a building permit on a lot, there's absolutely no reason why anybody would have any idea that anything was happening. If a decision's made, they would normally have, the clock wouldn't start until they had reason to know that it had happened. There's also, however, another appellate decision case where the court addresses where the third party had opportunity to be aware of things. It said, where the code officer filed his decision on April 4th, and it said the petitioners who were closely involved in proceedings before the planning board with regard to the project said they weren't aware of the determination made at that time. But they were involved, they were aware somewhat later, and then the court said the petitioners therefore had time to submit the appeal, and they failed to indicate how their lack of notice until May 15th prevented them from filing the timely appeal. So there the court was not basing it just on when they knew. They said because they were involved and they were aware of what was going on, they had an opportunity to know what was going on. They did hold them to the schedule. So there's some, there are different approaches to the way the courts have looked at this stuff. But there are all things that have to be sorted through, and there are a number of different decisions that are relevant here. There was an initial application that was submitted. It was then sent to the planning board, and that was I think it can pinpoint the date when that was done, which had both explicit directions and implicit things that were not directed to be done, which impliedly were determined not to be necessary. So they're going to have to sort through those things to see if, depending on which issue and which determination is being questioned, when it was set forth and when it would have been known. And those are all the procedural threshold things that have to be gotten through with respect to every appeals question. And then, if an appellant has satisfied all the requirements there, that they are aggrieved and they were timely, and it was a decision of the code enforcement officer and not something in action of the planning board or something else or somebody else, and they get through all of those things, then you actually begin to look at the merits and the code provisions that might apply and whether or not they have been applied properly or not. So it's quite a complicated thing and quite a technical thing. So
the public hearing is still open. There's a lot of people here. Does anybody have anything they want to add or say? And Terry and Allison, if you want to come up, you're pretty far away. Do you have anything you don't have anything to add or?
I just want to ask, did you guys get my letter? Because I didn't see
I did.
posted it.
We did.
You did, good. When?
It was stamped. When did we get it?
I think
It's
March
in.
9th, right
March what?
on. March 9th.
March 9th?
It was dated March 9th, but I think it changed about 7.
Thank you.
We got it, this is the original, March 9th, yeah. And that was received March 9th, yeah. Does anybody want to add anything or say anything in this regard, in this matter, for this application? Yes?
I just have a
You
question.
are?
I'm Gayla. Gail Greystone. My only question was when you were saying, when you were talking about, I just want to clear it. When something is going to take place and like a building or something that's on public land, or do you put up notices like around the area so that people
No,
know what's going on?
no.
So how do people then find out so they can either?
There's noticed in the newspaper. We don't put posts on telephone poles, if that's what you mean.
Yeah, that's what I mean.
Well, there are two things. Let's see this. Well, if somebody comes in to do something, it depends what it is. Let's say, for example, you have a vacant lot, it's zoned for single-family homes, and you want to build a single-family home, which is done by right, doesn't need any special use permit, doesn't need any site plan, doesn't need any board review, as long as you meet the basic parameters. You're not violating the setbacks, so it's like you got a parcel that's big enough for the house, you want to put the house there. You go to the building department and you put in a building permit request application to build a single-family house. And if it's all in compliance with the code, the zoning board never sees it, the planning board never sees it. There's no notice of any kind. Probably the first time that a neighbor might be aware of that would be if they start seeing some signs of activity there.
There's also would be a building permit issued, and that would be hanging in the window of any said project. But the only time the ZBA would hear anything would be if it didn't pass the building department, the building enforcers, if they didn't meet the criteria, like Ken said, and it would need an area variance or a site variance, or it would need a height variance, then it would come to this, and those need to be noticed in the newspaper.
Right. So that's the difference. Is if someone comes in, let's say again, single-family house lot that's permitted, but you're supposed to have a 50-foot setback, and because of the configuration, you want to be only 30 feet from the line. You need an area variance. So the building permit would not be issued. The building permit would be denied with a direction to go to the zoning board of appeals to request an area variance so you could build closer to the line of the code. And at that point, there is notice. It's going to be published, as we publish in the newspaper. It's going to be on the website under the zoning board, and the people immediately surrounding it, the 100 abutting neighbors, are going to get letters.
So like letters?
Yes.
And
but that only goes to the immediate people. So,
right. But
yeah, and then the other thing is if it's typically maybe more commercial related thing where you need a special use permit or a full site plan review, similarly, the code enforcement officer directs the application to, in most cases, the planning board, and notification is published. It's on the planning board agenda. It occurs at the planning board. It takes place in a public meeting. And if it's a special use permit, letters get sent out to the adjacent people there as well. So it depends on the
But to add to that, there's also, so in the case that someone needs a variance, then they would come in and we would hear their application. We would also, we make a next meeting to have a public hearing. And during that time, the CEO would send out a list, the applicant would send out a list to the neighbors in the area. But I just learned recently that that's not the requirement of the CEO, the code enforcement officer. That requirement is ultimately the obligation that is on the applicant, and information necessary for the applicant to carry out this duty is available to the applicant without the CEO's involvement. So Erin does this. I don't know if we can say we make a practice of it, but we do this because sometimes people don't know who, in fact, they need to send a notice to. And Erin has that information, and it's based on tax maps at the time, but that's notification that would be in addition to what would be in the newspaper. specifically to those people.
So my question goes back to, how does one even know, if you're not a newspaper reader, you know, and that's not your habit, how would you even know to look to know that something is changing?
Well, again, it depends on the case.
Yeah.
In some case, it would be when you first, if it doesn't require any zoning board or planning board review, it might be when someone starts to do something.
Right.
If it does require zoning board or planning board review, it would be going on with the planning board or zoning board for a couple of
Yeah.
months. And it is notified, it's on the website, I mean, that's where people find out about it.
It's
And
not
that's-
the obligation of the village to knock on everybody's door and tell them what's going on. There's points that it's assumed that of interest it's taking place in the village. When the price chopper went in, we had meetings for 2 years. And the minute they broke dirt, people said, "What's going on down there?" It's like, well, it's hard to back up, but there's things going on all the time, and to be involved is part of a resident's obligation.
In fact, the state law only requires it to be published in the newspaper. It doesn't even require any mailings. That's just a local thing that many municipalities do. But the state law does very little. It just publishes it in the newspaper, and then the meetings are going on, so people are following what's going on in the zoning planning boards. I'm not saying it's ideal, but I mean, but it's the law. We have to work within the law, and that is what's required.
People didn't know there
Which
was
is not to say they
election
couldn't do
yesterday.
more than that, but we are dealing with what is required, as a matter of law right now, that's, you know, we're dealing with what was done. And
Notices were put in the paper about the election yesterday, and I talked to a lot of village residents, and they went, "What? They didn't know there was an election yesterday." 37 people did, so this is,
I mean, I think, you know, the laws are kind of out, New York State laws are, they go back when everybody got newspapers, but that's, I mean, those are the laws we're dealing with, so.
Allison, you had your hand?
Yeah, I just had a quick question about you were mentioning the posted, like someone has a building permit, you post it in the window. Is that for just building permits or is that for like any construction?
It would be for one that would need a building permit.
Okay,
There's construction that doesn't have building permits that are in violation, but
right, so if you have a special use permit, but without a building permit, would that need a sign?
when you got approved, whatever you wanted to do and it was approved, it would be stated on, Aaron, correct me if I'm wrong, it would be stated on that permit, and it would be posted in the window for everyone to see.
Right, so I'm just saying Dicey doesn't have one. I was wondering if that would require one to have one.
No, it's a zoning permit, it's not a
Yeah.
building permit.
That's what I was saying, is
Yeah.
it just for special?
Building permit, yeah,
permits? So-
that's what we were talking about, yeah.
Right, so if the special use permit has it without a building permit, then
Right.
you wouldn't need it there. Okay, thank you.
So anyway, that was all preliminary stuff. So now we probably move on to actually dealing with the specific
Yeah.
issues. So
Should I keep the public hearing open?
probably don't need to. I think
Yeah.
we have the record, we have everything referred. Basically, any questions that come up can be referred to the record. So
Okay.
I don't think there's really much expectation of any new information.
So at this point, I'd like to make a motion to close the public hearing. Can I get a second? All in favor? Aye. Okay. Oh, moving forward. There's going to be a lot of referring to our attorney because of complications in this appeal. So we decided we're going to start number one, and
Well, let me go to the decision worksheet.
which is here.
It's on the, so,
You have that, right? Lori?
so we laid out threshold questions governing the appeal in its entirety. Who does the law authorize to make an appeal? We said aggrieved person. And 2, are the appellant's persons who are qualified and authorized to appeal as aggrieved persons? And we kind of did go over a lot of the last meeting.
And we determined that they had a right, they had a right to make the appeal, right? Didn't we?
You didn't formally vote on it, but I think they were discussing it for a while, and the board kind of said, okay, that.
Yeah, I mean, we're here.
Basically is, in being in close proximity, one of the other issues is whether the things being alleged are things that are protected by zoning, and aesthetic things, impacts, separation of different types of uses, those are all within zoning. A thing that it isn't, for example, which sometimes people have been rejected for, protection of business interests. There was one of the big foundational cases, it's like a gas station objecting to another gas station just because they didn't want the competition. And of course, zoning is not here to protect you against business competition, so they didn't have standing because it was not within the zone of interest that zoning is supposed to protect. But things that have to do with aesthetics and, as a visual impacts, separation of types of uses where you have residential here and a commercial or industrial there, these are all within zoning. So this board, I think, is accepting that. I would say that might not fly in a court of law if there were an Article 78 on that. And one of the reasons is a lot of cases take a more demanding line. For example, as I quoted a little earlier, this appellate division case has, quote, "For standing to sue, petitioners must show that they have suffered an injury in fact, distinct from that of the general public. There may be a higher burden to actually prove a true injury, not just allege something that you might have personally found objectionable or unappealing." So the fact that this board may accept this for standing now is no guarantee that it would be in a court on these facts. I just wanted to point that out. Okay, so then the threshold questions applicable to each specific allegation. So we're going to go one at a time. And the first one, which is the applicant's appeal the determination that the utility pole structure did not require a special use permit. Citing sections 11045A and 11045B, the applicants allege that the utility pole is a non-conforming use structure which requires a special use permit. The first question, threshold, is this appeal an appeal of an order, requirement, decision, interpretation, and determination made by the administrative official charged with enforcement of zoning code? I think that clearly, yes, that it was the zoning, that was the code enforcement officer making that determination. The second question, was the appeal that was filed January 5th, 2026, made within the 60-day time period, or possibly the adjusted time period from the time of the filing of the determination? So,
Some discussion, right? Because
when was the determination filed that the pole did not require a special use permit?
it was at the 10/31 date?
No,
Yeah.
that was, is that the one?
Yes.
Oh, that was the one, okay.
I'm sorry, 110, 30,
10.
10, yeah, 10. I thought you said Monday, I don't think so. So October. Yeah.
So, on the face, the filing of the appeal on January 5th is more than 60 days. So the question then, under some of the guidance from the courts, which is not easy to sort through, is there justification for not holding them to that time frame because they didn't know or couldn't have known or shouldn't have known, or should they be held to a time period? And that probably takes some discussion.
Yeah.
And they can weigh in on, if you want, you can discuss it with the parties and
Yeah.
their reiteration of what their views are on it.
Those dates coincide with what you have in your dates, your
Us,
10/31 and the January 5th?
I would say there was confusion around that because I didn't get that I got that information through the FOIA request that I didn't receive until January, but I put the request in, November, like very early, so I didn't get that information. I don't believe that was information given to us prior. That was internal information, because we did ask those questions repeatedly, but did not get an answer.
This is from minutes, yeah. Is this what you're pointing out here?
The dates that are, the dates for each package.
Applicant's appeal determined that the utility pole structure did not require special use permit. I don't see the dates, I'm sorry.
I mean, there's the letter, October 31st, 2025.
And stated October.
Oh, October 31,
And
okay,
the
great.
applicant stated December 7th.
Okay, so if it was December 7th, it was even earlier. Well, we talked about, what we discussed about it was the dates, but the actual attendance to planning board meetings and knowing of the process was ongoing. I mean, they were aware of the process.
Yeah, but also did they, to try to pin down this knowledge of this decision. I mean, you said you were asked for, what was it you were asking for?
Well, so
FOIA.
I know we're not supposed to mention the planning board, but just for context, we were always attending those planning board meetings, and we tried to ask questions, and we were shot down because it was, taken off the special use permit. We tried to ask, why, and then just before, we also had holiday break in between there, so there was a lot of everyone was not around. But I did email the enforcement officer and ask to meet in person with her. We were actively trying to, get answers, but, there was no, I haven't heard an answer yet.
So with that, do we assume that
I don't know.
it's really hard to know?
I know, it is hard. I mean,
Yeah, it's,
were you reviewing the files? Were you able to review the files? I know you.
Yeah, the trucks went up November 3rd, and
Say that what went up?
the trucks went up with the poles November 3rd, and the applicants emailed me, and I responded repeatedly that the pole did not require a special use permit.
How might Allison and Terry have
knowing
been
that.
aware or have?
Email. I have a copy, I don't have them on your account, but they're in my email.
Oh,
And they're part of the application that's online too. Or the application that was in front of the planning board. I don't know if that's still online or not, actually.
so you emailed?
Yeah, I responded pretty much every time they emailed.
And that's in your packet of stuff that you sent, right?
I don't think the correspondence was,
Oh.
because that was a lot.
We went back and forth. There was a lot of correspondence between us. There was a lot of questions. A lot of the neighbors were asking questions. I guess we just didn't know why it was removed, and then why we couldn't talk about it, because it was removed. So there was no real answers as to why it was, until recently, when we started discussing it, with the zoning board of appeals, we've had a little bit more clarification, but it's still a little unclear why it was removed.
Well, I mean, if we can pinpoint actual communications on that issue, it would probably
Be
be
helpful.
helpful to settle that question.
I would say it was the first week of November.
The what of November?
First week of November.
And we're comparing that to the January 5th made. Well, anyway, I do the math, it's more than 60 days.
Well, on the 31st it is, but
Yeah.
I mean, it'd be helpful if we get, I mean, if the email was, first few days of November and that was more than 60 days, that would probably be sound reason to say, well, they were made aware of 60 days, more than 60 days.
Right.
If they didn't have any reason, if they really didn't have any reasonable way to know about it until the middle of November or something, then you might say, well, they didn't really have a reasonable way to know until, if it was within 60 days when they reasonably put it on. So those could kind of clarify the issue.
Good. Do you have those emails? You don't have them with you, do you?
Oh, they're in my office.
Oh, they are.
Yeah.
Can she go get them?
I just have a quick question. Does that include like holiday break? Does the 60 days include like Thanksgiving?
It's calendar days.
Calendar days, yeah.
It's every day
Okay,
counts.
I'm just wondering, okay. Okay.
Okay, so we're waiting on that. So it would be a timely appeal, it would have to have been before the January.
That's 60 days. November's got 30 days, December's got 31. So it was on the 6th. 60 days later would be January.
Well, I see an email November 6th.
Yeah, that's what I was looking for, I don't know why I don't have that.
But it was, and
Where are you seeing that on this? I'm not just on the top, yeah.
and then, well, it was all caught.
November 6th.
But it's referring to emails that were received from Eric, I'm assuming something happened prior to that.
Yeah. Right. Yeah, that's what I was looking for, anyway. Yeah, it's all paperwork.
So let me ask, if they were technically 64 days following the posting of this that they should have seen, does that automatically disqualify their appeal?
If it was reason why they should have known at that point, if they persuasively showed that they didn't know until a later time, and they really didn't have a reasonable.
So black and white, yes, but Ken's saying,
If it happened in a way that they wouldn't have really had any reason to know about it or whatever, then course with some kind of extended time. You know, so, you know, if something just went on, there are times when things go on, the just doesn't have any reason for it, that it happens.
Yeah.
You know, this one, and that's kind of what's being
But
said.
the argument I seem to be hearing is that they were attempting to find out what was going on and were having difficulty for some reason or other. And I'm not sure that we need to ascribe blame to that, but if they were attempting to and somehow or other it was unavailable, does that make a difference?
Yeah, if they really, you know, if their attempt was sufficient and such, yeah.
Yeah.
So,
You know, if this is pertinent, anything, this is like that. I think that's what Aaron's looking for. Have you found it?
Oh, I thought you said that's right.
Does that help?
Well, it points to something. That is the 6th, but it is referring to something that happened before. But we don't know if it's earlier the 6th or earlier. So, because there are 2 of them. On the 6th at 3:54, I wrote the thing about Aaron is responding to stuff, and then they wrote back to me later on the 6th. So I don't know, I was writing about something that Aaron had sent, but I don't know when that was, but she's going to presumably find that out. Don't know exactly what was said in it, but maybe we can find out.
Well, can we wait on that and? Well,
But the second one is
good to
that-
know that, right? Because that would be.
Well, yeah.
Second one's pretty similar. It cites different code sections. All right. The first 2 both involve the pole and the special use permit. So they would both be addressed by this.
So there was information that went out from Aaron's office, but it addressed different aspects of this in different times. At different times?
There were a lot of communications at different times, so yes, I mean, I'm trying to find which ones on which dates might have addressed the question.
Yeah, okay.
So do we know this date of determination here on 2B? And
It's going to probably be the same information. They both involve the same question.
it's going to be the 10,
They're both about whether the pole needed special use.
right.
They refer to different code sections, but if it was said they didn't need it and it was more than 60 days, then they're both going to be voided. But if it's within 60 days, then there's 2 different code sections that they looked at.
Well, I don't know what we're going to find. I don't know what Aaron's going to find that we don't have in here, because this was what she submitted to us, so, right?
It's got a bunch of emails in it somewhere, doesn't it?
Are you finding any more? I think we can.
Well, while we're waiting, one thing, we could jump ahead to number because I think we established pretty clearly. Section 5 is citing sections 110.14B and 110.15. It's saying that the height variance should be considered with site plan review. Those sections were not determinations of the code enforcement officer, because they are referring to sections the section, one of them has to do with what can be certain heights, but the one that is the action, 110.15G4D, it says where a proposed site plan contains one or more features that do not comply with the dimensional regulations of this chapter, application may be made to the Zoning Board of Appeals for an area variance without a decision or determination by the code enforcement officer. The planning board shall decide
October
whether
5th.
such area variance
October
application.
5th. November 5th.
Shall occur as a prerequisite. So this one, number 5, is under planning board review procedures. And first, it's permissive that an applicant may go directly to the ZBA if they want, without a code enforcement directing them to. And it is the planning board to decide how to handle it. So it's not actually addressing an action of the code enforcement officer. So I think that number 5 is not reviewable because it's a discretionary thing by the applicant and the planning board that doesn't involve the code enforcement.
So then we don't need to know about the date of that.
For number 5, no. That's just not, no. I'm sorry, you just found an email?
Yeah.
Yeah, it's November 5th.
Number 5th? Did you bring it up?
Right here, that was my response.
This is for number 1?
Yeah.
Well, that's okay, 60 days.
November 5th and January 61. From December 30th.
Yeah.
Yeah, so it's more than 60. From November 5th to January 5th. is
Oh, okay,
60
yes,
days.
yes, yes. But what was the date you just said? 11. You said, what did you say? What date did you just give us?
November 5th.
November 5th.
And Kenneth, and you made a formal response on October, or November 6th.
Which one am I reading here?
Yeah. November 6th is 60 days.
Right, yeah.
November 5th is
Yeah.
61 days.
It is 2 months. They were working. It's 61 days, okay. And it seems to me that that's within the range of, I mean, the idea is whether they were consistently and appropriate. I mean, that's- I have a difference of 1 day is not sufficient to disqualify.
Okay? How do you feel, Larry?
Well, I would just say, if you decide that that is actual notice of the decision, and it's 61 days, it is barred. There is no discretion in that way. You would have to determine that they did not have actual knowledge at that time. If they do have actual knowledge 61 days, that's out. If it's not actual knowledge, but there's a reason why they didn't, it is possible to give discretion. So the only way you can say, you have to say, this thing on November 5th did not actually give them notice of the decision. So, but you grab the letter, you have to.
Right.
But that would be the standard for saying it.
Okay.
I need to look at that a little bit more then. I'm not ready to decide on that yet. What?
This was sent to,
I sent to Alice.
so as far as we know, this was actually delivered. This was sent.
It's in the,
Yeah.
Yeah, her response is right above it.
Okay.
Well, I think the question is to, like, what was going on? What was the discussion prior to this? It seems to be that there was knowledge of it. But I'm confused by it, I have to say.
I didn't get a chance to really read the,
I mean, also, we could move on and try to deal with the stuff that you feel we can answer. And
Yeah,
if
let's
you feel
do that.
the need to really scrutinize some more records before a final decision on, you do have 62 days to do it. I mean, but, you know, if this is something you really feel you do the parcel with writings and then this and that between now and the next meeting, you could do that and try to get through maybe the rest of it.
Yeah, I just want to be fair in the
Yeah.
conversation. I just don't want to, you know,
I see
compare.
it.
Huh?
I see it original.
This one?
Yeah.
All right, so let me be absolutely clear that number one here is it's being alleged that they didn't, that they didn't know about, I'm sorry. The question is, when did they know that this Aaron's determination had been made about the utility pole not being part of the regular expansion? And that letter is her statement about that, which she sent on the 5th of November. And that would seem to indicate that that's what this item here is about, that they had knowledge. Okay.
Okay, can we, you right? Can we get on to what we can solve at this point? I'm not ready to check off on that.
All right. Well, that sort of addresses both 1 and 2, because they're both about the same
Yeah.
question. About the, so on 3, the applicants appealed the determination that the expansion of the utility facility was, they appealed the determination that the expansion of the utility facility was permissible because it was within the 25% expansion of a non-conforming use permitted by section 11045. Citing section 11045A, the applicants alleged that the facility expansion exceeded 25%. Is this an appeal of an order of the code enforcement officer? It clearly is.
Yes.
What's the date of determining that it was permissible because it was within the 25% expansion? When would that have been decided?
That was, when the application was submitted in August. I think it was like August 15th.
I think that decision was when the planning board went through, which was November 24th.
The denial on the building permit is when the decision was made. Then it gets sent to the planning board.
August 15th.
August 15th? And Aaron, could you re-explain how you come up with that, how you came up with your calculations and formula that you use?
So, not there yet. The first question is, did you make a decision? When did you make the decision?
All right. Okay,
And if it's clear that it's August 15th,
then we can go, we can do that.
then it would be on time, and there's ample time to know that before we get to how it's calculated. For the building permit.
Papers, I don't know what to do with them.
Well, I mean, that is, we saw that that would be a threshold thing, but in the meantime, just to put your calculation, why it was, I guess, I'm jumping ahead,
Yeah.
maybe it's not to do, but 25% was based on,
I took the measurement of the structure itself, not the area that was within the fencing. So I took the square footage of the structure itself, and then calculated 25% of that. But the actual expansion was only for the one breaker that was in the back, because the other breaker is within the footprint of the current structure.
yeah, from what I've written down.
So it was like 5%.
512 feet or something. It was like the pad, the new
Yes,
pad.
yeah, the concrete pad size is really all that we can rule on. Because we don't regulate the infrastructure at all. The uniform code and building code and energy code does not regulate that.
So it's not for the expansion of the fence like the original statement said.
Yeah, because the backyard, so many fences in the backyard, that's not considered part of the structure, part of their structure.
Right. In any case, the increase in the building would be limited by the increase in the pad.
Correct. Yeah.
Yeah, so what I've had written down is that you had the existing footprint, I had a number of 2,096, and which would allow up to 524 square, and you said the pad is 105, and your interpretation of the expansion is the expansion of the footprint of the facility?
Yeah, not the whole fenced-in area.
Okay. And your question is well,
Yeah,
and
and then
Is that a
there's
reasonable-
or there, and your calculation for 25% is calculated out?
Well, yeah, so I'm confused about doing a structural, like, calculation. The application actually says footprint, like, so that's the footprint of the entire expansion. So that's what so I calculated off of the graphs and NYSEG drawings. So I took the numbers that were there, the original size of the substation, plus what was added, the dimensionals of the footprint.
But very often when an applicant puts on an application is not what the determination actually is. So they put it in that expansion, but the way it's determined is by our code. So that's what I use to make the determination.
You use the footprint.
Right.
And that calculation that you came up with is in the code,
Correct.
it's in the
Yeah.
instruction that
It's
you
20,
have.
no, the instructions, are the 25% is in the code.
Yeah, 25%, but how you came up with that?
Yes, by the structure itself, not by the fenced-in area, because.
No, I understand that, but the determination of why you use that formula.
Yes, based on the increase of the non-conformance and the increase of the fencing, because the fencing is non-conforming because it's 7 feet high. So,
Is there any reason to think that the actual increase in size of the building would be greater than what you calculated?
no. I went off of their plans and the size of the concrete pad. And I mean, if they don't do what is on the application, then it's a violation. But as long as they conform to what the application was approved for, and
Yes, question?
Yeah, I'd like to point out that explanation only came about last month when we were at the appeals meeting. When we started out, the explanation was a whole different format. It was not that explanation. It was changed from the first to most recent.
Well, that calculation had been reflected when it was filed, right? When you had your
they
filing.
never asked.
They couldn't have changed.
I was never
it.
asked about the calculation. I was only asked about the whole.
Well, the question really for you is, the code says it can expand up to 25%.
Yeah.
And
I
so,
think-
what do you think
I think Erin's calculations are reasonable.
the
way she-
footprint based on the expansion of the footprint of the facility?
Yeah, it's
It's
reasonable. I think if you, I guess what I was trying to get to is that calculation and that way of calculating that is something that is reflective of your training and your how it's done. It's not, you didn't just make that up.
No, when I first started, my interpretation of the code was way different than it is now after going through all the trainings and
Yeah,
certifications.
exactly, yeah.
Okay, and so can we confirm that August 15th?
Yeah,
Is there, do we actually time that? I know it's in the minutes, do we?
I believe it was the day that the application was submitted,
Which is,
August 15th,
yes,
and then it was determined to go to the planning board
yeah.
Okay.
because of that.
Yeah, the denial was August 15th, and it's sent to the planning board, and obviously the planning board doesn't meet until they have the meeting, so, and that's when the review starts. But the actual denial, determination was August 15th.
We were not notified though, so in August, we had no idea that this was happening. We got no official notification.
When did the board start to meet?
The September meeting, which they were at.
Yes, in September.
Still not notified.
That's still 4 months
Yeah.
before
Yeah.
January 5th, though.
yeah.
And then again in October,
Correct. And November.
and then again in May. So the 3 meetings, there were more than 60 days.
Absolutely.
Determination was on the date that it was filed, when it's stamped and filed, not when it's decided or talked about. They were talking about it throughout the whole planning board process, and that decision was made.
It's not their decision. We're not talking about the planning board decision, though. It's when Aaron sent it to the planning board and said, this is subject to
This is the
25% review, that's the decision that is subject to the appeal, and that's what she did in August, which they took up at September meeting, October meeting, November
None
meeting.
of that was ever discussed or brought to our attention, that was a 5% increase and that it was only the structure. I've never, that's the first time I'm hearing about it, like she said.
But I mean, this whole thing was,
It an
that was like the
application for
fundamental what this thing
non-conforming
was all about.
25%.
And that had been going on for 3 full meetings. And you also think that her calculation was,
Yeah, I think it's reasonable and correct. It's the way,
Don, you feel comfortable making a decision on who then on both of those bases?
yeah. So we're going from August 5th to,
And the fact that it
August
was,
15th.
that plus the fact that it was taken up at 3 meetings in September, October, November, which were all from more than 6 days. And they were present. All right, so 1 and 2 are still, that's the ones that we
Yeah, 1 and 2 are hanging because of that.
The 6th one, public hearing notice is not provided. There are a lot of things that bear on that one.
Yeah.
Um,
What?
So one question is this an order requiring decision, interpretation, or determination of the code officer? They referred to section 11060B, which is actually the zoning board public hearing, which isn't even relevant, but basically the same provision applies for planning board under 11016 F7C. So what it says is the applicant shall provide notice to the public hearing to the owners of all property. That's what you were talking about before, that the code obligation to send out the notice is actually,
It's not really our obligation,
is upon the applicant.
application. So getting notice is how can we be held, the fact that we do this, that we've done it, does that make it that we should do it? Yeah, that's it. Well, we've done it up to now, so why?
Well, the legal burden's on the applicant.
Right.
The code officer is, it's been practiced as a courtesy to list the ones. It's an interesting question, 'cause, you know,
I think it would be, it's a courtesy, but
Yes.
I think if the applicant came back and only listed 2 people, and there were more people that needed to be noticed, it would be your responsibility to say maybe, or maybe it's not your responsibility,
Yeah, the
but
applicant
to
is
say you don't
always
have enough.
access to the tax roll, so I offered to provide that information.
Like the application isn't,
Yeah.
the application
And we
is.
provide them with the public hearing notice that goes in the paper, and that's the notice that we send to the.
Right, and then it would be designed, it would be, I'm sorry.
Did you say they don't have access to the tax roll? 'Cause that's online.
Well, yeah, I mean, they do, but, yeah, but it.
That's how it's determined.
Yeah, I go onto the county website, and they can do it, but.
And then as a zoning board, if we got this application at the ZBA, we would say, well, this application isn't complete because it didn't notify enough people.
Yeah.
Didn't
And then after-
notify that person and that person and that person.
And then after the first meeting, they went and sent it on to, they asked for all the neighbors along Fairview Ave, and I gave them some on Center Street as well as Mill Street too, that were all notified as well.
I'm having trouble hearing you.
They say that after the September meeting, also notified all the neighbors on Fairview Ave as well as Center Street and Mill Street. I provided them with the, because they wanted, after the meeting, there was many people that said that they were notified and they should have been notified, so they say they were not notified.
When I look at, I'm not, you know, actually looking at the language of the code, I know I have a hard time thinking that it's actually a determination of the code,
Yeah.
because for one thing, it doesn't carry any legal weight. If it is a list that's provided, but if they send it out according to that list, to the planning board, for example, and people recognize that it didn't have the people on it, the planning board could say, well, this doesn't have everybody on it. And make them resend it, you know, tell them.
Does the planning board require the same
For special use permits,
request for notices
Yeah.
as we do? Yes, by
Yeah.
certified mail?
but that would, it wouldn't really require, there's nothing to be overruled, because there's no rule.
Yeah, yeah.
So, I mean, it is a practice and a courtesy, but I'm not real comfortable calling it myself a determination.
Yeah.
I think it's a helpful thing, but it doesn't actually, for example, if it's wrong on its face, it's inadequate. It doesn't need to be overruled. Anybody could see it didn't have the people on it. Like the planning board otherwise can't object to what the code enforcement officer says. Then the planning board doesn't have the authority to override. So, like, for example, when the code officer says, these are the parameters of your review, they go with that. They don't get to say, oh, no, we think something else. But if the people aren't notified, if they don't need, you don't appeal it, have to appeal it to the ZBA, they just, anybody can say, these people are notified, you need to send it to them.
And the code of that notification is within feet from the project, right? It's 500 feet? Or anybody within
100 feet.
100 feet, so, right, 500 feet. And that's
The
what.
planning board can actually request further notification, but only 100 feet is required.
So if an entity down the road, say there was a daycare center down the road and they needed to, because of traffic or whatever, they might be included in that notification. But
Yeah, actually. Actually, that's a good point.
she kindly provided a list, right?
She does it out of,
Out of courtesy.
Yeah,
But it's not her job to enforce them,
no, it's a procedure, it's
Right,
part of the
right.
procedure of the review process.
so,
it wouldn't, who collects the receipts of, the clerk collects the receipts of the certified mail,
Yeah,
right?
they usually bring it to the next meeting or the
Secretary? Yeah, collects those receipts.
Yeah, and it also says the applicant shall provide notice of the public hearing and information regarding the project to all owners of property, abutting the subject property and all other owners within 100 feet, or such additional distances that the planning board may deem advisable not to exceed 400 feet. So it does put the range of people within the authority of the planning board
Yeah.
and the burden, the legal burden to do it on the applicant. So I think it's not really quite right to say that that's a determination of the code enforcement officer. The planning board say, well, we want to do it to everybody within 200, up to 250 feet.
Right. Well, they're gonna do at least what she says, and they might add some.
Yeah.
So they can override they can't really override your bound, your who's.
They can, yeah, any applicant can add more to it if they want to.
So,
Whereas in this case, applicant would be NICEAG.
NICEAG. NICEAG had the responsibility
Notifying people.
notifying.
and notifying whoever the planning board, at least to 100 feet, but also if the planning board had said 200 feet, 500 feet, or up to 400 feet. But
Right, because those, that determined, we never saw it, so we didn't have any notification sent out. So it was just from the planning board. The planning board's initial saying, correct me if I'm wrong, do you tell the planning board, do you give the planning board a list of people within that 100 feet distance, or is it just
It's
assumed?
provided, yes, it's provided to the planning board as part of the application, to the process.
Okay. And they could say, we think, yeah,
Should be
they're-
done.
So if there's a complaint made, isn't it her job to investigate and to make it clear?
say that again, I'm sorry.
So if there's a complaint made
Yeah,
about the notices, isn't it her job as CEO to investigate how many feet actually is it? And then communicate the complaint?
it would be a complaint, I think that's the wrong word. If there was an issue about who was informed, then that would be up to the planning board's determination to say, Aaron, we want to add this and this and this. I don't know where a complaint would come in. Say if you didn't get a notice,
Right.
and you say you didn't get a
We
notice.
didn't get a notice and we complained over and over again.
Formal complaints.
I mean, within 100 feet and nobody's acknowledging it. And it's the law. And when NICEAG contacted us, it was not done certified mail. They stuck the paper in the mail. NICEAG was not complete on their.
My son,
Were there any other receipts, certified mail receipts returned in the application?
No, they provided all the certified receipts for the addresses that were provided.
Sam?
again, let me get back to the other.
Yes.
Well, this is still being discussed, but there are a bunch of cases where actual participation tends to remediate defects in the delivery. That the appellants were present at the meetings in September and October, November and December. Courts have tended to say if there was a flaw in the public notice, but they're actually participating fully, there isn't really prejudice for the failure to get the case out. So they're fully informed
Yeah.
and obviously are present and fully involved. So there's that side of it.
And that's stated in your case law that you, right?
Yeah. So
Yeah.
Well, okay, so let me restate for my own use. In this process that we're talking about here in item 6, Normally what happens, and what happened in this case, was Aaron collected a list of people who were within a particular range, 100 feet of the construction, gave it to NYSEG. They sent out notices of one kind or another that they thought were sufficient. And that should have, according to our side of it, or the town side, should have been enough for everybody to be informed. These folks claim they weren't informed.
Well, there's a question about the distance from the parcel, that when Aaron calculated it, it didn't reach to their parcel.
Yeah, and I provided that in all the,
And then-
how I calculated it.
And then they calculated it and found that the closest distance of their parcel to the NYSEG parcel was slightly under 100 feet. So they
And that's the back corner?
Well, we share a driveway with NYSEG. So our back driveway is our property, Ripple's property, Columbia County property, and NYSEG. We all share that driveway. So I would say our property abuts NYSEG.
How do you share it? By
Well,
lease or by
yeah, we
common?
have like a right of way, I
We
guess.
drive our car down the driveway and enter 66
I don't know, it's
on
almost right
NYSEG
there.
property.
But we have to go over NYSEG property. You know, when they bring their trucks in, we can't go down that driveway because their trucks are blocking our driveway. So, you know, it's a shared access road, I guess. But when you know, and then the property line is swervy, and it depends on where you calculate it from. It just felt, you know, strange that, you know, this tower pops up and we never got noticed for it.
And how's the code determine?
Well, I provided the maps and.
Yeah, I saw that.
That is, I mean,
Yeah, the
it
county
does say
property
100 feet from the closest, I mean, it does describe
From the
100 feet, from the 100, all owners within 100 feet from the exterior boundaries of the lot or parcel involved in the application. So it's, if the person's property comes within 100 feet of the exterior boundaries of the lot or parcel involved in the application.
Well, but then you were saying, I believe, Ken, that this particular point has to do with whether they knew about what was
Well, I think
happening.
that
And if
that's
they were
probably,
going to meetings,
I
that
think-
was probably sufficient.
well, I think that based on some of these cases, the distance might have been 98 feet, might have been 102 feet, whatever, there seems to be a difference there, but the fact that they have actual participation in all, the point of the meeting, the point of the notice is to make sure people have awareness to participate or whatever. And that's what there are cases that indicate when someone has had actual participation in the process throughout, that there wasn't a prejudice, that they weren't disadvantaged in such a way to invalidate the action, even if there was a flawed notice process, because they weren't excluded from the process, they were clearly there and participating. So
So in this case, the next line in the logic would be that they were there,
yeah,
and therefore they
That's
did
excellent,
have that, they did have that information. That's the point that I think
yeah,
has been
there
made.
are a bunch of cases that kind of go along that direction. So
Okay.
I think that, to me, that would be the, I think that based on this, that's a resolution of this, that we're not in the dark, you know, if there wasn't, even if there was a technical failure of a few feet in the notice, that they did know of it, they were made aware of it, they were present, they fully participated, so there isn't really any harm if there was a technical flaw in the notice delivery, or they didn't get one.
Does it invalidate the process?
Doesn't invalidate the whole process.
And then we have to look at the whole question of whether or not it was Aaron's required obligation to do this in the first place. And if NICEAG made an error, then it's not really something we're dealing with, not dealing with what NICEAG didn't do.
But wouldn't that be her job to enforce what NICEAG does? She's the code enforcement officer, so that would be her job to enforce the code, right?
If there was a violation, hear what you said? Is it Aaron's job to enforce that aspect of it, mistake? If
But it's not a determination.
Huh?
It wasn't a determination.
Yeah.
Oftentimes, once they are out, it's just dealt by the boards. They see the letters, they see what came back. I don't know if
NICEAG did provide further notice. It didn't go out certified mail, but they did provide further notice to the rest of the neighborhood.
I know there's another case on that that I read that also said that failure to do it certified doesn't really invalidate the letter.
Can you speak up? Sorry.
No, I was saying that there was another, I read a lot of cases trying to get background on this, and I know there was another one that did specifically get into that where notice wasn't certified, but people were aware and participated. They said that does not invalidate the determinations ultimately, or the decisions of the boards. That wasn't a fatal flaw.
We have to deal with the date of determination and...
Well, that's the question, this is even a determination,
Right.
per se.
Well, I think that's a legal issue that I think is blurry because of if we're not required, if it's something we do gratis, supply those names. You never supplied names to NICEAG, did you?
I supplied
Oh, you did,
the first
okay.
round and the second round.
Yeah, okay. Then I don't think it's a determination.
So you're saying that legally, sending certified mail to these folks was not a requirement, that's just a courtesy?
No,
No, it is.
it is, but it's the burden on the applicant, not the
It's not
code
code
enforcement.
enforcement. And of their previous involvement in the process is...
Kind of two different levels of being addressed here. One is the sending of this code enforcement obligation decision, or is it not? And the code does say the applicant shall send these things out by certified mail, so it's an obligation, but is there a decision of the planning board? I mean, is there a decision of the code enforcement officer there? That's one of the questions. And the second one is, if they didn't get certified mail, but they still were present for the meetings in September, October, November, and such,
Does that
override the paper, that they didn't get the technical paper notice the way they were supposed to? And court decisions tend to point that, yes, if you are actually fully participating and they are present and you know what a meeting like that, if there's a flaw in the paper delivery aspect, or that should have taken place, it isn't a fatal flaw when people had the full opportunity to actually, when they were present and participating, they didn't suffer a harm by not getting the paper, because the point of the paper is to make sure that they can participate. So that's...
So the lack of the paper didn't prevent them from attending
Right.
the meetings? And it wasn't something that the code enforcement officer was responsible for.
Well, those are the two things that are in front of you, yeah.
Well, I don't see them in the wording of this number 6 here. How does this discussion appeal to that statement? Is the appeal an appeal of an order required?
So that's what we're discussing, whether or not it was her obligation in the first place to do this. And it was
You know, is it an
preempted
order?
by- and/or it was
Is it
planning.
an order of determination?
Right.
Usually those are things that carry, have a legal weight.
And the planning board had a right to increase that and say, this isn't right, so who has the final determination and say on who gets notified and who doesn't? It's a good question, right? I mean,
So, I mean, the obligation is on the applicant to send these things out. They go in there and say, well, here's a list of those people. But it doesn't change. It's not now saying that it doesn't change anything. The laws are still, we gotta send it out to those 100, everyone with 100 feet, and they're supposed to do it. She's being helpful in providing a list. She's not,
Assuming the
I
responsibility.
don't, you know, that's the question. I don't,
you'd have to question it, because if she made an error in that list and those people weren't aware of that obligation, that figured, okay, this is what Aaron told me to do, and this is what I did.
it wouldn't help them.
Yeah.
I mean, that's the thing, it wouldn't help them. The fact that she said it doesn't help them. Whereas, if you make a determination on something, if she makes a determination about a variance or something, and then, you know, if someone goes in and says whatever, something not, there are things that she does that actually carry legal weight. And the only way it can change is an actual appeal to the zoning board or something like that. The list doesn't, giving people the names doesn't actually carry any legal weight, because they still have the same obligation to send it to everybody, and they have, and the applicants have that obligation.
Right.
If Aaron, also normally, like if someone comes with a building, an application for building permit, the code enforcement or the building inspector has a duty to make a decision to either grant it or deny it, or she must do something, deal with it. Because that's a duty, and so the decisions come out of that duty. She doesn't have to do this. This is something they have to do. And there's nothing in the code that says anything.
And she's only,
They could just be told, well, go to the maps, go to the tax rolls, and you gotta make sure you do this. For simplicity's sake,
and this is only happening in
Yeah,
terms
so-
of a ZBA, a variance needed, or a special use
Yeah,
permit,
so-
zoning board issue. It's not, if it was just a building, if nothing, if it all passed, no one would be notified, like we were saying earlier. It'd be nothing.
I mean, that's what, you know, you're the ones who have to vote
Yeah.
and make a decision.
Well,
That's
Say no.
Yeah, I would say no too, because it's just, that it's what, that it's not a determination. It's not a- yeah, yeah. I don't feel it is too. There's not enough here to sway me the other way.
And then,
Okay. Do you feel differently?
I feel the same issue. What was that?
No.
No, I don't think it's, I don't think it interferes with the overall issues here. And if there was an obligation that was not carried out, it was by, I say, not by the code enforcement officer. And if these folks didn't get notified in time by paper, they did have opportunity.
Yeah, I feel the same way.
So, I think that this one is one that I
So those reached the actions or the decision on our worksheet for what we had to cover. I don't know if we are ready to, we have some loose ends.
Well, there's, and so 1 and 2 were kind of pending your careful consideration of the communications to see whether or not you felt that was,
Yeah.
that's 1 and 2. 3 was the 25%, which you felt code enforcement officers
Was correct.
was valid. All right, 4. Right, 4 and 5 had to do with the height and whether they needed variance. 5 was excluded because it wasn't a code officer determination of his claim. But number 4, applicants appeal a determination that the utility pole did not require an area variance for height. And then citing sections 110.14b and 110.8, the applicants allege that the utility pole considered by the CEO is not one of the things that can be more than 35 feet in height without a variance, and that it needs a height variance. So, is it an appeal of an order of the code enforcement officer? Yes. When was the determination made that the pole didn't need an area variance?
What's that?
When was your determination made and filed that the utility pole did not require an area variance for height?
It was put in writing October 31st.
Well, when the application first came in, oh, okay.
Yeah.
So is that part of that same letter, that same email from the 5th? Is that addressed?
Yeah.
That's the one here? Yeah.
Oh, the October 31st. That's the letter, the other
Right.
one.
That was the
So
letter.
these are all kind of the same. So when we were talking about this, when the application first came in, back in August, and you sent it to the planning board, but you didn't treat the pole as part of the application at all, so you didn't make any decisions on it with respect to the height or anything else, because you didn't treat it as, you weren't even considering it part of what was going on in the plan. Okay. So then it kind of came up as its own issue, and from your perspective, it came up as its own issue, and
Yeah.
they're asking about, does this need a
Yeah, the
height
process
variance?
was taking a long time, and they say we needed to move forward and determined it was a replacement of a utility pole.
And that was in October 31st then?
Yeah.
Okay.
This is the whole thing about building height versus structure height versus this and that.
So what's that letter, the letter you, from the 5th, the email? So talk about that in there. This one's really got a lot of stuff going on. So in the November 5th email, it says utility pole replacements don't ever require building permits, so they don't come in to you ordinarily. But then, when you cite section 110.14b, this is where there's a lot of stuff going on.
Yeah, well, there was a lot of stuff coming at me, and
Yeah.
it's very difficult to concentrate.
Because you referred to 110.14b, and it said,
Yeah, that refers to more like poles and flagpoles that go on top of buildings.
yeah, because that doesn't list those things.
Yeah,
But I mean, there's a lot of stuff in the code. Did a lot of work on this, trying to sort this one out, and there's a lot of inconsistency in the code, in that so section 110.8 says, except as hereinafter provided, no building or structure or part thereof shall hereafter be erected, structurally altered, enlarged, moved, etc., except in conformity with the provisions of the density control schedule for the district in which such building or structure is located on the zoning map. It refers to both buildings and structures at that point. And then after that preliminary statement, it then says, no building shall exceed the maximum height. And so it talks initially about buildings or structures conforming with the density control schedule. And then it says, only uses the word building, no building shall exceed the maximum height. And then in the code, in the density control schedule, there are height regulations, and they only refer to maximum building height. They don't refer to structure height, and in the definitions of the code, there are differences between buildings and structures. So, on one hand, this 110.8 says buildings and structures have to conform to the density control schedule. When you go to the density control schedule, it only has a height limit for buildings. And it also says right here in 110.8 that no building shall exceed the maximum height. So there are two things here that are in place to regulate the height of things, and they both specifically refer to the height of buildings and exclude limitations on the height of structures. Then, and there's a principle, a lot of these things, principle in law, it's a Latin phrase, but it basically means that when there's a list of, or reference to one or certain things, and doesn't include other things, there's a presumption that the law is intended to refer to apply to the things that it does list, and is not intended to apply to the things that it doesn't list. So, in that reading, when you're looking at the section 110.8 and the density control schedule, they both refer to building height, and specifically use the term building and not building and structure. According to that principle, you would infer that it was not intended to apply to structures. But then in 110.14b, it says, except as stipulated below, structures shall not exceed the applicable district height regulations unless approved by the ZBA. And then it lists, and it says some things about not constituting a hazard, does not infringe on solar access, and is no more than 10% of the roof area. And then it lists a bunch of things, television and radio towers, church spires, belfries, monuments, fire towers, ornamental towers and spires, chimneys, elevator bulkheads, smokestacks, and flagpoles. Doesn't list utility poles.
Excuse me.
Yeah.
When I read that, I thought that they were referring to structures that were parts of buildings, that is on top
Yes.
of
And that-
buildings.
and
Right,
that
that's what I said.
Yeah,
That's how Aaron is interpreting
yeah,
it.
that's
Yeah.
how that's what she's saying, yeah.
And so that wouldn't apply to a freestanding.
No, it actually would.
And it wouldn't necessarily apply to utility pole because they're not covered under
Yes.
not covered under the village regulation
Or the
code.
New York State Uniform
New York
Code
State.
and Energy Code, correct.
Thanks.
But they do if it's less than a certain voltage we talked about.
No, the Uniform Code doesn't regulate.
Uniform doesn't
whatsoever.
regulate that, okay. So you're going by that,
Yeah,
first of all.
yeah,
And
I asked New York State, and that's what they
Yeah.
told me, so there's no difference in wattage or kilowatts, whatever. It
right.
applies to the New York State Uniform Code.
So there's some,
I think there is ambiguity in this reading, but I think the New York State Code and the way Aaron has to deal with it is overrides seems to me, overrides the ambiguity. It seems to be like, if you're
Well, that's also-
Did
I
the
mean,
original
there's another-
structure already exceed?
What's that?
Did
Yeah,
the original?
yeah, there were two 50-foot
Right.
poles.
Yeah.
So they
You're replacing
already,
it with one 60-foot pole.
right, those already exceeded it.
yeah.
Yeah, so the footprint is
Right.
decreasing, the whole area is decreasing.
and, as I researched, there's also another principle set out in many cases in New York that says, there's a principle that ambiguities in a zoning law must be construed in the subject landowner's favor. And what it says is the Court of Appeals, since zoning regulations are in derogation of the common law, they must be strictly construed against the municipality which is enacted and seeks to enforce them. Any ambiguity in the language used in such regulations must be resolved in favor of the property owner. And that's repeated in a lot of cases.
And that makes perfect sense to me, why that's there. I mean, you can't, the person who's stating the law, placing the law in place can't, if you have ambiguity in that, then it's your
Well,
law.
the idea is, people have property rights, there has to be a very clear statement of law to deprive them of, and that's what it comes from. So there does, and these are all, I read a lot of cases and spent a lot of time trying to sort through this stuff, but I think that's the principle that comes forward over and over. There are a lot of things going on there, to try to weigh all these to reach a conclusion. I have to leave in your hands.
I think they're all consistent.
Okay?
I think they're all what?
Consistent. The thing that we were talking about, it has to do with the difference between structures and buildings. Structures on tops of buildings apparently are different from structures that are freestanding.
Yeah.
And these different paragraphs that Ken has cited seem to be perfectly consistent.
Yeah, I agree, and also that the state laws telling you this overrides village codes, right? Overrides that.
This is not a state authorized project, though.
This is what?
This is not a state authorized project. It is completely under local zoning.
Yeah, it's not exempt from the,
It's not.
this isn't the big ones. There's.
Yeah, no, I get that.
Right, there's no exemption.
But
So that's why I went for the special use permit, so it's not exempt from the local zoning, that's why I went for the increase of the non-conformance.
So, and I'm also confused, structures don't have a height limit?
It's no height limitation.
They don't have no, okay. In village code, structures can be,
100 feet.
okay, good to know.
I think the one next to my house.
I'll be
is-
building a 100-foot tower then.
Still need a building permit.
Well, I'm going back to what you're saying, that the utility poles
No.
aren't regulated under height. The ones we have there are already.
Yeah, all around the village, not
They're
only
already,
35
it's
feet.
not like they have
All
20-foot pole there that is in regulation, and they want to put a,
Yeah,
so it's,
250 foot to 160 foot.
But these aren't on state and county roads. This is a privately owned lot in the village of Chatham, and it's a non-conforming lot. The whole lot,
It's privately owned by NICEAG.
but the whole lot is a non-conforming lot. Anything on that lot should get a special use permit. It's not on the street, it's not a sidewalk utility pole.
It's actually not a non-conforming lot because the lot is in conformance with the square footage. The structure is non-conforming, not the lot.
Then why didn't the structure get a special use permit if it's not conforming?
It did.
Where is it?
It got a special use permit.
that was,
No, it did not. The pole?
The pole did not, because poles don't.
The pole
Well, that's what we're talking about.
Yeah, they're not included.
yeah, and it wasn't included in that.
So the pole is residential? It's not,
No, it's
It
utility,
doesn't.
it's a part of the utility infrastructure. And the replacement of utility poles is never gonna get a building permit. Not a single utility pole that gets replaced
Where
is
is
ever
that
gonna
law?
get a special use permit or a variance.
Where is it in the code that utility poles get exemptions? Where is it in the code that corporations get exemptions and residents have to grovel for a 4-foot fence? I'm very confused about that.
I think one of the logical explanations is that if somebody hits a telephone pole and it goes down, or some need for a telephone pole has to go up, and every single person had to get a permit for that, nothing would get done.
But this is
Nothing
not
would
a
happen.
road. This is not a road
It's,
utility pole.
It's not
it doesn't matter where it's located.
And it's giant, and if it falls, it's gonna hit multiple houses.
There's a lot of poles that would hit houses. Any pole on the street would hit a house. Like it's just, do you use electricity? You don't use candlelight, right? I mean,
we
it's
do,
just,
and back in the last
You
couple
have
of
to do it
days, we
for 48
did.
hours.
that's just,
I think the only way you bring that pole down is 747, maybe.
Yes, yes. thank
That
you.
is a
Well, to do
monster pole.
anything to talk about planning board at all, we'll
Yeah.
have to do a 70,
We're gonna say-
Article 70, yeah.
Under any review, there are, utilities are, because of, utilities are providing essential services are treated differently under any review. There is cases on that stuff.
And the FCC used to.
Yeah.
Yes, but this is a specific case where there's no PSC oversight and it's not state authorized.
But I think, as a utility-related, providing essential services, the courts are deferential to them, that municipalities are supposed to be a lot more accommodating to them than.
I understand that,
than
yes,
organizations.
because they're a public necessity, I do understand that.
I mean, this stuff is really unclear. I mean, really, I'm not trying to say it isn't. It's very, very unclear in a lot of ways. That's what everyone's trying to sort through
Absolutely, and we've been trying to gain some
Yeah.
clarity on it as well, and that's all we're trying to do. It's all we've been trying to do for 6 months is to kind of gain some clarity, and we just felt like we've been mocked, laughed at, ignored. I don't know. That's the treatment that we have received. I have nothing personally against the code enforcement officer, I just couldn't talk about the planning board, that's why I had to take it personally. I have nothing against her, she just does fabulous at her job. But, this forum has forced us to pinpoint it at her, I never wanted to do that. I never wanted to attack her, but unfortunately, that's.
no,
those are the decisions that can be questioned.
Yeah,
Those
yeah,
are
that's-
the
Yes.
code enforcement. It's true. But, so I guess that leads you guys first too, that you want
Yeah.
to spend more time.
I want to spend more time on it, and I look at the hour. We do have a little bit of an issue in that to resolve this. Is it possible to hold a special meeting, a special hearing to make because we have to make a decision in public? I'm going to be gone.
You're going to hear from them in April, aren't you?
Yeah, we'll be here for April, sorry. Thanks, Ken, for reminding me of that.
Well, I think that's
Trying
what
to
we
get out of
wanted to make sure we did it tonight, in case,
No, you're right.
in
you're right.
case this
I will
happened,
be,
we wanted to be
yes.
able to wrap it up, in case we couldn't do it tonight, so.
Right. So let's, okay. Can
All right.
we move to close for tonight?
The public hearing's closed, you can
Yeah.
just,
Public
yes, you're
hearing's
gonna
closed.
turn over, close the meeting tonight, we'll resume it at the April meeting.
At the April meeting.
Finish
If
these
we have
last
other
steps.
business, we have other business. We should
Yeah,
have
you can
another-
scrutinize the communications and see how you feel about those last two things.
Okay. That sound all right to everybody? Make a motion to adjourn. Second?
Staying here later.